Happy Thursday evening. Is it Thirsty Thursday? I don't know. We're doing a Lawyer Reacts Live because I haven't had a chance to read the appellate brief from Johnny Depp. I'm guessing maybe you haven't either. Maybe you have. I know others have been covering it today. I want to take a look at what it says. And instead of me just reading it by myself, I'm hearing echo of me. Sorry. Instead of reading it just by myself, I figured we could all do it together. We talked about it today on the Thursday Coffee and Cursey Words. So let me know what you're drinking, where you're coming in from. I have water, fizzy water with ice, which I try not to drink on stream because I'm want to chew ice, and a little bit of peanut butter whiskey because I have a feeling we're going to need it. Tonight has gone completely off the rails. Like, I finished up our live stream and went immediately into 2 back-to-back meetings. During that time, the State Bar of California, somewhere in there, dropped the craziest report about Tom Girardi. And I was like, oh, we were just talking about you, boo. A judge in Illinois was talking about your crimes. And the State Bar is like, are bad. So sorry. We're trying to figure out what the fuck happened there. I can tell you what I think happened there. The LA Times has been on that for a year and a half, 2, but cool. So I just dropped a reel on that over on the Instagram. I will be dropping that same reel over on the TikTok and on my Quick Bits channel later tonight, but I was already late enough to get here and had to go to the restroom. And priorities. Tonight, it was time to have a whiskey. So then, as my night is like back-to-back meetings, the State Bar shit goes down. And then my kid's like, so we're done an hour early. So I go to pick up my kiddo from practice, and there's an accident on the freeway. See, living in Los Angeles, there were lots of different ways to get places generally. Not so much in Middle Tennessee. So the one accident on the freeway is near where I need to get past the freeway to get to my house. And so everyone's trying to get off the freeway to find an alternative route, which is 2-lane roads going different directions. So it took us like an hour to get home. And I was looking at my kid at one point. I'm like, we live here. We live here now. Welcome to your new house. He's like, the view's nice. There's deer sometimes. And at least the gas station's down the way if we need a bathroom. I'm like, yeah, we're never leaving. We're never getting home. We're never getting home. So today was just absolutely BANANAS. And then our stream today went long, but I loved our stream today. We had such a great chat because Tuesday or Thursday or whatever day it is. And as I was on the stream today, Rob from Law and Lumber is like, yo, here's the appeals brief. I'm like, I have to finish talking about the suit that we started talking about on Tuesday because we didn't get to finish talking about the boozy suit on Tuesday because we were talking about Amber Heard being homeless. There's so much happening. I am again exasperated. Exasperated. Let's roll the intro. We're just doing the one thing, and then we're going to chat and take questions. We're going to do it. I put the lights on a new setting tonight. I haven't decided if I'm living or annoyed. So we're just going to roll the intro and let it go for the night and see what we think. Did anyone notice already? Did anyone notice? I don't know. I'll check the chat and see, but it's time. It's time to roll the intro. Y'all, welcome to a nice nighttime stream. Cheers. Good to see you, Law Nerds. I'm going to try to make sure I've got my documents pulled up. Let's go. It's time. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey Words. This channel is where the law nerds unite to talk about facts, not fuckery. We're almost ready. We're professionals here. We have a We Are Professionals fan now. Yes, we are. Yes, we are. It's glorious. And we are almost ready. Look, I'm living for the 2-screen layout, but also sometimes it takes everything a minute to be ready. I can't believe how quickly this was accessed, and I'm so thankful for all of you that were like, yo, it's going down. And then for Rob from Lon Lumber for being like, and here it is. Like the research attorney on point today and all week really, because Hogue was in the chat being like, hey, I know we're doing a research together stream. Here's the document that you're looking for. I'm like, thanks everybody. I feel so supported. I appreciate it. All of you are the best. So chat is bae. Love the other attorneys in law here up on the YouTubes and how much support. So let us go over this opening brief. We do not have Amber Heard's opening brief yet. We don't. I love kind of the formalized OG style of this appeals brief, because all of this is determined. Like literally all of this is determined in advance, and I am kind of living for it. So let's just go through. Let's see where. There we go. We are ready. We are ready to roll. It's going down. I'm yelling timber. Yep. Going to be that kind of a, it's always that kind of a night. I should just stop saying that. It's always that kind of a night. Let's pull up this appellate brief. I love it. Look, I need my in a world voice. In the Court of Appeals of Virginia, record number 1072-22-4. John C. Depp II, appellant, versus Amber Laura Heard, appellee. Brief of appellant. You know that all of this is determined by the courts. The courts are like, we will only accept it if it feels vaguely like Old English. Okay, sure. Somebody in the chat, wait. Daydreaming Pixie says it looks like the opening of a Disney film only if that Disney film is like the OG Robin Hood with the foxes. Oh, that's the opening of the Disney film that it looks like. Only that one. Only that one. It's just, it's very formal. Lawyers, we take our shit seriously. I love it. Who do they, like, do they have to pay? I have so many questions for Rob. I'm sure he'll address it. But you've got to pay for the formatting to do the thing. None of this is easy. All of this has to be formatted specifically. I'm sure they have people that do that. Emily, how much work have you done in appellate work? No, I like to be in court talking about things. I don't want to just read other documents all the time. Ugh. If I want to do that, I still could have been, a research attorney. I want to be in the court talking about the things. Somebody's asking, where is Rottenborn? Well, Rottenborn is not one of Johnny Depp's lawyers, so his name's not at this. This is the Brown Rudnick attorneys. So, Robin Hood and Little John walking through the forest. Damn it! We're never going to move on. We're never moving on. I love that movie so much. We're never moving on. We're never moving on. And now my kids are like, what is this? I'm like, hand-drawn animation is what it is. Hand-drawn animation is what it is. Embrace it. It's great. Love it. Alrighty. Counsels, counsels for appellant, everyone. Michelle over on the Facebooks, do you think Johnny Depp can win his appeal? I don't know yet. We're going to find out together. You know why? Because this is a first look. So let's find out together. I'll tell you what I think. However, what I think and what an appellate judge thinks might be very different. I will say that on the designations, there were some very interesting areas of law, and I noted them somewhere. The chat noted them as our research attorneys. And we were like, I wonder what they're going to say about this and this and that. And that's what we're going to do here. So Charla asked, what is he appealing? We're going to go through that now. They're going to tell you everything that is being appealed. Everything that's being appealed. So this is all, again, this is the can you follow instructions part of being a lawyer, or can you send it to someone who can follow instructions to format? All of these formattings are designated very specifically. It's like, it needs to look the way I want it to look. The formatting I hate the most is probably the Supreme Court formatting, where there's like this much text and like this much margins. But why though? Like, how did that get determined? Who decided that that was the proper way to write things in text that was like this with margins that were like that? It's so fucking annoying. Can't we just not? Ugh. Anyway, let's go. Table of authorities, statement of the case, introduction, assignments of errors. That's where we're going to get the questions. The assignments of errors are going to give you the little kind of blurbs real quick. Statements of facts, argument. This is where we're going to get the meat and potatoes of the thing. Standard of review is going to set out the law, and then discussion where we're going to get more law. The trial court erred in excluding the full articles containing the Waldman statements, on and on. So, conclusion and certificate. 35 pages. These are the case law that they're citing. Love the double spacing. Hey, Virginia Appellate Court. Thanks, man. We like your spacing. We appreciate it. We also think your font's kind of sassy. So cheers to you, Appellate Court of Virginia. The Georgia Appellate Court, their font's not nearly as fun as this. So, hey, gold star, 10 points to Virginia. 50 points to Virginia for double spacing in a normal sized margin. Yes. Yes, Virginia. Thank you. Thank you for being an appellate court with normal fucking rules and like a 12-point font instead of itty bitty fonts squished all up into the middle. You know how I feel about it. You give me a 40+ line paper and I'm want to lose my mind for 45 minutes screaming about the fact that the formatting is off. Those streams exist. Those streams exist. Those streams exist. So they do. Formatting is so nice. Holy shit. It's legible. It's legible. Go Virginia. Oh, so helpful. Lucinda, yeah, the longer I stream for the day, the sassier I tend to get. That's just fair. A quick question real quick, and then I'm going to get into it a little bit more. We're just going. What is pro hoc vice? Pro hoc vice means an attorney that is not licensed in the state who has been granted leave to practice in the state. So some of these attorneys for Depp are licensed and reside and work at firms elsewhere. So Camille Vasquez is easy for me because she and I went to the same law school, so I tend to remember where she's located a little bit easier, but she's at the Irvine office of Brown Rudnick, licensed in California. So she's pro hoc vice in Virginia because they've allowed her to appear in Virginia. I believe Jessica Myers is New York. Dennison is either like New York or DC. So these attorneys are licensed not in Virginia, but allowed to practice this case in Virginia with attorneys that are licensed in Virginia. So that's why they've got that pro hoc vice designation down there. So that's why. So let us continue on with our document. Statement of the case. This appeal arises from a 6-week jury trial on competing claims for defamation. Appellant Johnny Depp, we're just going to go with Johnny Depp, alleged that Amber Heard defamed him by implying in an op-ed in the Washington Post that he had abused her during their relationship and brief marriage and sexually assaulted her. I mean, that was what the headline implied, but me being picky. By counterclaim, Ms. Heard alleged that one of Mr. Depp's attorneys, non-party Adam Waldman, defamed her in 3 statements, collectively the Waldman statements, to the United Kingdom tabloid The Daily Mail, claiming that Ms. Heard's claims of abuse were false. Footnote 1. She alleged that Mr. Depp was vicariously liable for his attorney's statements. Ms. Heard's counterclaim originally alleged 3 claims against Mr. Depp. Mr. Depp filed a demurrer and plea in bar to the counterclaim. And then that's where it's in the record 6256 through 74, which the trial court largely granted. It dismissed 2 of the counts entirely, leaving a single count of defamation based on 3 statements. So that's saying, just FYI, Your Honor, a lot of her claims are already yeeted. Your honors, just so you know, other things were yeeted. Mr. Depp filed a motion for summary judgment on a single count counterclaim on March 24th, 2022. The court denied the motion. The case was tried from April 11th through May 27th. It feels like it was yesterday and 100 years ago, all at the same time. On May 24th, at the end of Ms. Heard's case, Mr. Depp made a motion to strike her claims. We all watched it, which was denied. Mr. Depp renewed such a motion on May 26th, which was also denied. On May 27th, the jury retired to deliberate. On June 1st, it returned its verdict, which overwhelmingly favored Mr. Depp. The jury found that Ms. Heard defamed Mr. Depp in the op-ed, awarding Mr. Depp $10 million in compensatory, $5 million in punitive damages. Footnote 2 is probably going to be about the fact that the award was reduced to the statutory cap of $350,000. Yes, that is true. On the counterclaim, the jury found in Mr. Depp's favor on 2 of the 3 Waldman statements, but in favor of Ms. Heard on the 3rd Waldman statement. That is the only statement at issue in this appeal. You can't appeal when you win. As a lot of people tend to say, appeals are for losers. Because if you win, there's no point in appealing. So they had to lose something to appeal it. On June 24th, the trial court entered judgment on the jury's verdicts. Footnote 3, Mr. Depp timely noted his appeal on July 22nd. On July 1st, 2022, Ms. Heard filed a 42-page post-trial motion asking the trial court to set aside the verdict on Mr. Depp's claims, which the court denied on July 13th, 2022. That motion is not relevant to this appeal or anything else. That's the motion that claimed that the juror wasn't even the juror. The juror's not even the juror. Amber Heard doesn't even live in the US. Like, nothing is as it seems. It's all mysterious. It may or may not be lawful law, but it is definitely mysterious. So those motions were delightful, truly delightful. It just like the straws that were being grasped at in that jury motion it was just delightful. It was delightful to cover. I can't even be mad at it because it was delightful to cover. Delightful. However, the trial, oh no, we got to get back to the introduction. Footnote. The jury's emphatic favorable verdict, facts, on all 3 defamatory statements alleged in his complaint fully vindicated Mr. Depp and restored his reputation. Someone alert the Washington Post and Rolling Stone and others. Somebody alert the media that Johnny Depp has been vindicated and his reputation restored. Let them know. Somebody tell them. I mean, his lawyers are going to tell them. Look, the appellate briefs are going to be partly PR statements. They are written not just for the Court of Appeals, but they are also written for the media to understand and report on. And they are written for all of us to understand and report on. So these are written with a dual purpose. And so far, on page 2, we're going to be here forever. And so far, written easily. I like how concise the writing has been from Depp's team the whole time. A little bit of shade, a little bit of snark, but a really easy writing to follow. Really easy writing to follow. And I appreciate that. Indeed, Mr. Depp prevailed in the trial court on virtually all material issues, and the verdict of the jury and judgment of the trial court represent an intelligent and well-reasoned decision on the merits after a full and fair trial, and should be largely, though not entirely, affirmed. Right, because if you're going to entirely affirm it, you're not appealing. So largely, but just there's a caveat. Like, just accept this one little piece. But there's some interesting legal issues for that one little piece. Look, if Amber Heard has interesting legal issues, I'm here for it too. Johnny Depp has interesting legal issues. Why? Because they're trying to hold him responsible for shit his lawyer said, and we don't know how the jury determined that there was actual malice as to the lawyer when he said shit. There are questions here. However, the trial court was confronted with a number of novel and complex legal and factual issues, and although the trial court decided the vast majority of these issues sensibly and correctly, a few things were erroneous. I think that that is a very fair way to say, Your Honor, this is not even a snarky with all due respect. This is a with tremendous respect. There are a few things that we disagree with. And this is a very good way to write it. We agree, but we have a disagreement here. Reasonable minds can differ, but we hope that the appellate court will side with us. I'm going to stop moving this back and forth. I'm annoying myself. Apologies. Mr. Depp does not appeal the verdict on his claim, nor does he appeal the verdict in his favor. Because why? Nor does he appeal the verdict in his favor on 2 of the 3 Waldman statements. His appeal relates solely to the Waldman statement on which Ms. Heard prevailed, obviously. I don't think they're explaining this to the appellate court. I think they're explaining this to people who won't understand. Ms. Heard prevailed. To the sole Waldman statement on which Ms. Heard prevailed, a statement in the Daily Mail article dated April 27, 2020. The judgment in Ms. Heard's favor on that lone statement is erroneous. So just this little bit. Just a little bit. I want to see. God, we reached into the archives for that one. I want to see you wiggle it. Where do the songs come from? It's a mystery of ADHD. Ms. Heard's claim was fatally flawed, and the trial court should have granted Mr. Depp's motion for summary judgment and motion to strike the evidence for 3 reasons. Ooh, 3. Let us do those things. 3. First, Mr. Depp cannot be held liable for Mr. Waldman's statements as a matter of law. That's the matter of law that I want to see. I want to see. I will probably read the case law on this after we get here. I want to see it. Amy Van Dyken, good to see you in the chat, friend. I want to see the law on this because it's very interesting holding someone responsible for something someone else said when that someone else is not their employee and maybe not their agent. That's very interesting to me. Ms. Heard sought to hold Mr. Depp liable for the April 27th Waldman statement on a pure theory of vicarious liability, contending that Mr. Depp was liable merely because Mr. Waldman had been retained by Depp as his attorney and was therefore his agent. But Mr. Waldman's allowed to speak. He has a right to say things. He has a right to say his opinion. So, I saw a comment that I was trying to star and it ran away from me because there's a lot of us in the chat this evening. Where did it go? It was Miss C said he wasn't speaking on his behalf, right? I don't think they proved that Waldman was speaking on Depp's behalf. I don't think they proved that. But we're going to see that argument, I think, as we go through this. As a matter of law, Waldman is an independent contractor. He's not in-house counsel to Johnny Depp. Johnny Depp is not like Mercedes-Benz, where you have in-house attorneys, or Twitter or Facebook or any of these massive corporations that have lawyers in-house, where the lawyer's making a statement about the company they work for. You could reasonably assume that the lawyer's making it on behalf of the company because that is where they work. They're speaking for their employer. But when it comes to a lawyer hired by an individual, that lawyer works for themselves, not the individual. So they're not an employee, which matters. But as a matter of law, Waldman is an independent contractor whose alleged tortious conduct is not automatically attributable to Mr. Depp. Indeed, a wealth of authorities supports limiting a client's liability for alleged tortious conduct by an attorney, and the court should impose that same limit here. Which, again, I'm going to probably harken back to the Girardi case a bit tonight. Can you imagine if a client for Tom Girardi that got paid in full was then being sued by another client of Tom Girardi saying, you got my money? Don't sing it. Don't sing ODB. Just stop it. Hey, today, baby, I got you. Imagine, that's not speech, but saying you're responsible for what your lawyer did. It's an interesting thing. It might be a rough analogy, but it's an interesting thing. Second, because Ms. Heard proceeded against Mr. Depp at trial on a purely vicarious theory of liability, She was required to present evidence.
Evidence. Stacks and stacks of evidence.
She was required to present evidence that Mr. Waldman committed each element of the tort of defamation. What's coming next? Malice, including that he acted with actual malice. No evidence of Mr. Waldman's actual malice was presented at trial, so the judgment against Mr. Depp cannot be sustained. Do you know what Adam Waldman presented evidence of trial? His Zoom connection was good. He knew how to not mute his mic, that the same objections, same grounds, and that his skin is unreasonably good. Like, it's just unfairly good. That's what we learned from Adam Waldman. Oh, and that he thought Amber Heard committed perjury. That's what we learned. That's what we learned during his testimony. Glorious skin. He can work the Zooms, and same grounds, same objections, same grounds. And he knows what attorney-client privilege is, and that he thought Amber Heard committed perjury. That's what we learned. Really. That's all we learned. We did not learn about actual malice. And I think when we look at the statement made by Waldman, and you have to remember, the statement made by Waldman was, spilled a little wine or whatever. He might have believed that that is what happened based on information that he had. Let's keep reading. Third, the April 27th Waldman statement, viewed in context matters, is a non-actionable statement of opinion insufficient to support a claim for defamation. That's why they are attacking the fact that the entire article didn't come in. Here's my feeling on that before we get to any of this. If Amber Heard didn't want that entire article in, then she shouldn't have brought causes of action based on the article, unless there are parts of the article that refer to not her. Everything in the article that refers to her should have come in. She brought it up. You opened the door. You want to go there? We're going there. Mention it all. However you want to say it. In addition to erroneously denying Depp's motion for summary judgment and motion to strike, the court also erred in excluding from evidence the complete Daily Mail articles containing the statements. 2, refusing to give jury instructions as to Waldman's status as an independent contractor. So these are assignments of error. Assignments of error. The trial court erred in denying Mr. Depp's motion for summary judgment as to Ms. Heard's counterclaim and Mr. Depp's motion to strike the evidence as to Ms. Heard's counterclaim. Waldman is an independent contractor, so they're arguing that as a matter of law. Waldman is an independent contractor. Depp is not liable for Waldman's alleged tortious conduct as a matter of law. Heard failed to present clear and convincing evidence that Waldman made the counterclaim statements with actual malice. The statements are not actionable statements sufficient to support a counterclaim for defamation or support a claim for defamation. Preserved. And then we have the preservations. Mr. Depp's memoranda to sustain, demur, plea, and bar all counterclaims. This is all of the places where Depp preserved these rights. These are all the times that we preserved that. The trial court erred in refusing Mr. Depp's proposed jury instructions 22, 23, 24 as to whether Waldman was an independent contractor. And then this is where it was preserved in the record. So they're citing the court back to see where we did the thing. Remember, we talked about this for all of you that watched the Brooks trial, and we talked about the judge preserving the record for appeal. There are times in court where you have to use it or lose it. So if you don't preserve an issue for appeal, you might not get to appeal because you didn't raise it at the time. You don't get to think about it later and go, whoopsie doodle. So sorry, Muffin. We'd like to point that out now. You have to do it at the time, which to Mr. Brooks and anyone else representing themselves is why you need a lawyer to spot those issues in the moment. Lawyers are put through rigorous, stressful, anxiety-inducing training where you have to sit in a time-constrained, stressful environment and spot issues. All law exams and class. That is a huge part of what you do. You have to see that it's an issue and raise that issue at the time to preserve it so you can argue it later if you need to. And so that's what these preservations are saying. Look, we did it. We said this was a problem before. This isn't new. We raised the issue when we were supposed to. The trial court erred in excluding from evidence the full unredacted version of Mr. Depp's exhibits, 881 A, B, and C, which are copies of news articles in which the Waldman statements appear, instead admitting only redacted versions that showed the Waldman statements out of context. And then that's where that was preserved. Statement of facts. Facts. In connection with her counterclaim, Ms. Heard contended at trial that Mr. Waldman, acting as Depp's agent, defamed her in 3 statements to the UK tabloid, the Daily Mail. The first Waldman statement quoted in the Daily Mail dated April 8th, 2020, and stated that Heard used fake sexual violence allegations and promoted sexual violence hoax facts. The article also contained a general discussion of the dispute and litigation between Depp and Heard. Footnote 4. The article noted, for instance, that Miss Heard's lurid 300-page filing cataloging the horrific abuse she claims to have suffered at Mr. Depp's hands. An interesting footnote. Why, though? Anyway. Including a discussion of the litigation and quotes from attorneys adverse to Mr. Depp. So there were quotes from presumably Heard's attorneys as well. The jury did not find this statement to be defamatory. Yeah, the hoax statement they didn't find to be defamatory. Always interesting. The second Waldman statement was quoted in a June 24th, 2020 Daily Mail article and stated that Ms. Heard's allegations were a hoax. The article also included a quote from Heard's attorneys that, quote, "We believe Amber and we believe in Amber." Elaine, I have questions. But again, you want your attorney to believe you and believe in you. That's fair. And a summary of both Mr. Depp's and Ms. Heard's side of the disputes. To be fair, you probably can't put a recitation of both perspectives of the side of the dispute in an article to the jury in a case where they're deciding things. So there might be things in there that truly cannot come in for context. The jury did not find this statement to be defamatory either. The April 27th Waldman statement, the sole statement which the jury found in Ms. Heard's favor, is contained in a Daily Mail article dated April 27th, 2020, with the headline, "Exclusive, I needed to report an assault. Listen to 911 call made the night Johnny Depp and Amber Heard had a blowout fight that ended their toxic 18-month marriage, but both claim tape backs up their version of events." That's the longest fucking headline I've ever seen. It's very Daily Mail of them. The April 27th article describes a recording of a phone call to police the night of May 21st, 2016, a date on which Ms. Heard alleged Mr. Depp threw a phone at her and roughed up their apartments at the ECB. The last time I was in LA, I went out to dinner, and the restaurant we were at, I had no idea would have a view of the ECB. So I sat down and I was like, ha! It's staring at me. Eddie, who I'm having dinner with, is like, "What is staring at you?" I'm like, "The ECB. The ECB is staring at me." It's through all dinner. It's right there. And then we had a very long conversation about this case. The April 27th article comments that, quote, "Heard's attorney says phone records and police department logs vindicate Heard's account of the final shocking episode of domestic violence she endured before filing for divorce." I don't think Depp's attorneys want that before the jury, though. Ad Comet, "The ECB won't let me be or let me be me on MTV." They try to shut me down on MTV. Chat is bae. EDB needs to go to the ECB. We might need to take pictures. Wait. Isn't Elaine's initials Elaine Charlson Bredehoft? Isn't Elaine's initials actually ECB? Elaine. Elaine. We're never going to escape. Ever. No, stop singing We're Never Ever Getting Back Together, chat. I know you wanted to. We're singing new Taylor Swift. No, we'll sing any Taylor Swift. Okay. So that statement in the article, they probably don't want in front of the jury. Like, Heard's attorney says phone records and police department logs vindicates Heard's account of the final shocking episode of domestic violence she endured before filing. I don't know if they want that before the jury. Depp's legal team says this recording does the precise opposite, however, by raising discrepancies in the various account Heard and her allies had given of the notorious dust-up. Yeah. No, I can see where the court's concerned about, like, even as we're going through these statements, I can see why the court's concerned. I would have to go back and read the article. But I get it. Like, you can't put some of this before a jury when they're the finders of fact. In details Ms. Heard's various allegations about the abuse she claims to have suffered on May 21st, 2016, noting that, quote, the domestic violence case ultimately fizzled when two LAPD officers who responded to the 8:27 p.m. call, Officer Sines and Officer Haddon, said they never found any evidence of a crime. Yeah, I get that too. The April 27th article further states that Depp's lawyer, Adam Waldman, said the various discrepancies prove that nothing Heard and her friends said about the events of May 21st, 2016 could be considered credible. I mean, that's context. But I can see why this was difficult. My memory is much clearer. I can see why this is difficult. It sets out Waldman's purportedly defamatory statement. Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. This is where the jury had an issue, because I think the jury found that that's not what the cops said, and that I think the jury was like, this statement of facts does not align with what the officers testified to. I think that's how they made that decision. Phoenix Night Rose, this chat is bae. As always, we're a very diverse group. They set Mr. Depp up by calling the cops, and the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their stories straight under the direction of a lawyer and a publicist, and then placed the second 911 call. The April 27th article also includes quotes from Mr. Waldman that Ms. Heard did not include in her defamation claim, quote, but even this didn't have the desired effect because two domestic abuse trained LAPD officers would later provide a pair of sworn depositions saying that they saw no evidence of a crime. These lies about who made the calls and when are just the tip of the iceberg, as the evidence will show in court. Finally, it presents a contrary view, quoting Ms. Heard's attorneys at the time. Heard's legal team rejected these allegations as fantasies. Mr. Depp's representations about the 911 calls the night of May 21st, 2016 are false, and Mr. Depp and his lawyers should know better. Her attorney, Roberta Kaplan, quote, all the evidence, including sworn testimony from multiple witnesses, phone records, and police department logs, are consistent with the truthful account given by a witness favorable to Ms. Heard. The name is not there. All right. Evidence relating to the Waldman statements at trial. Ms. Heard presented no evidence at trial that Mr. Depp was personally involved in directing or making any of the three Waldman statements. Indeed, Mr. Depp testified that he had never even seen the Waldman statements prior to the filing of the counterclaim in August 2020. Waldman has a professional license, is the owner and managing member of his own law firm, and provides legal services to his clients, establishing that he's an independent contractor. Waldman was retained by Depp in October 2016 and still represented Depp at the time of his trial testimony. So Waldman is still, well, is that past tense? Still represented Depp at the time of his trial testimony. But Mr. Depp is not his only client. Not an employee. Waldman's relationship with Depp is solely one of an attorney-client, and he represented Mr. Depp in various litigation matters, including his litigation against Ms. Heard. Waldman testified that while he believed he had some knowledge of the conduct of Mr. Depp and Ms. Heard, he never personally witnessed any interactions between them prior to his retention in October 2016 after their separation. Waldman testified that he made each of the Waldman statements. Ms. Heard did not present any evidence on whether or why Waldman believed each of his specific statements. Because attorney-client privilege, that's why. In response to a more general inquiry about Ms. Heard's allegations, however, Waldman testified at length on why he believed that Ms. Heard's allegations against Depp were false, describing physical evidence and identifying multiple witnesses whose testimony he believed contradicted her allegations. He also testified that he had filed a claim with the LAPD against Heard for perjury due to her claims that Mr. Depp abused her and that he presented them with information that established her perjury. I was shocked. I was shocked that they didn't dismiss this. I was shocked that they still went through this at trial, knowing that Waldman, I had an itch and now we're so red. Oh, it's so fun to have highly reactive fair skin. Delight. With this, I'm surprised Heard didn't dismiss these claims right before trial, because if she had, none of this testimony that he thought it was actually perjury would have come in. Argument. The trial court erred in denying Mr. Depp's motion for summary judgment and motion to strike. Standard of review. In ruling on the motion, the court normally considers all relevant portions of the record in the light most favorable to the non-moving party. Right. Light most favorable to Heard, and draws reasonable inferences in favor of the non-moving party. However, an appellate court in Virginia on the issue of punitive damages or where actual malice, interesting that actual malice has a specific appeals standard, makes you wonder how much this comes up. Probably a bit. In the appellate court in Virginia on the issue of punitive damages or where malice must be proven, the court must independently decide whether the evidence on the record on appeal is sufficient to support a finding of the New York Times' actual malice by clear and convincing proof. That's really interesting. So, the appellate court gets to decide on its own whether there's proof of malice. In addition, questions of law are subject to de novo review. De novo meaning new or fresh or on its own. They get to review it fresh. Whether an alleged defamatory statement is, quote, an actionable statement of fact or non-actionable opinion is a matter of law to be determined by the court and is reviewed de novo. So they get to decide as a matter of law, not a matter of fact, when you get to the appellate court. Drea said, so there's 2 muffin references now. Definitely need at least an emoji. Motion granted. We need a muffin emoji. There are two. We're never getting away from muffin references again. Under most circumstances, whether a person is an employee or an independent contractor is generally a question of fact for the jury, but where, as here, the evidence admits of only one conclusion. God, sometimes I hate the way appellate courts write. When there's only one conclusion, the question becomes a matter of law, and that is also reviewed de novo. So the court gets to look at this new and decide as a matter of law whether the evidence in the record suggests that this person's an independent contractor or an employee. I think it was clear from the evidence, personal opinion, I think it was clear from the evidence presented at trial that he's an independent contractor and not like in-house counsel for Johnny Depp. Discussion. Waldman is an independent contractor. Heard presented no evidence that Depp was personally involved in directing or making the Waldman statements. Instead, she chose to pursue a pure vicarious liability for shit someone else did. What are my cats doing? It was loud. A pure vicarious liability claim against Mr. Depp, contending that he was liable for Waldman's alleged defamatory statements simply because Mr. Waldman was his attorney. Heard's proposed jury instructions on her counterclaim, which the trial court adopted and gave to the jury, were based solely on vicarious liability theory and did not require a finding of any conduct by Mr. Depp in connection with the Waldman statements. That claim fails on a threshold issue, whether as a matter of law, Depp can be held liable for the intentional tort of defamation based solely on statements made by his attorney on a pure agency theory. I know that sounds like a lot, but it's really getting to the heart of this case as to the cause of action that Depp lost, saying, okay, for vicarious liability on an agency theory, can we hold someone responsible for an intentional tort? There's like 4 layers of it. So if you feel like you're peeling back an onion, yes. In the context of vicarious liability, Virginia has long recognized the distinction between servants and independent contractors. Servants meaning employees. Look, the languaging in case law tends to be very outdated and kind of draconian. It just is. So just, I will try to modernize it in my brain, but a lot of this language comes from case law from like the 1800s, and they just pull it forward and never change the word from servant to employee. Ever. The languaging in cases. Ugh. Let's see. That follows well-established rule that a principal is generally not liable for the tortious conduct of an independent contractor. Recognize that in Virginia, the doctrine of respondeat superior, it's like my fucking 1L year in law school. We've gotten to respondeat superior. What is happening? We're all going back to law school. What is happening? I'm living. All right. Recognizing that in Virginia, the doctrine of respondeat superior imposes tort liability on an employer for the negligent acts of employees, i.e., its servants, but not for the negligent acts of an independent contractor. And declining to adopt an exception to this rule for the tortious actions of an independent contractor who was an ostensible or apparent agent. Quote, the theory on which a master is held liable for his servant's conduct is based on the right of the master, actual or potential, that's the employer, to control that conduct and to see to it that negligent acts which cause injury to others do not occur. So look, I know you guys are saying servant peasants, we know who we are. We're the randos. That sounds like a Harry Potter spell. What would a Harry Potter respondeat superior spell be? It kind of does. Respondeat superior. And you summon people. It's really saying that an employee has some means of control over or an employer has some means of control over their employee. Therefore, if their employee goes amok, you can hold them responsible because they have some level of control of what they're doing. With an independent contractor, less control, therefore less liability. Hopefully that makes sense. I just saw a super chat about respondeat superior. Mambo Fuego said, holy smokes, I'm doing a 1L memo on vicarious liability and the doctrine of respondeat superior. Welcome. It never ends. And this is a really interesting context for it. So I hope you're nerding out along with me because the context is very interesting. If the relation between them does not give the employer that power, right, the level of control over the employee, then he should not be held liable or responsible for an occurrence over which he had no control. So if you tell an employee to do something like build a foam pit at a convention center, let's say, and the employee does exactly what you asked to your specifications, you can't sue the employee, but you can sue the employer. But if somebody hires an independent company to build a foam pit at a convention center, it's something like a TwitchCon, and somebody literally breaks their fucking back because of it, then You can sue the company that you hired to do it because you just said, can you build a foam pit? And they're like, we got you. And you didn't direct them on how to do it. You just paid them to do it and they fucked it up. So then you can sue them. Hopefully that makes sense in that context. Let's keep going. In assessing whether a person is an independent contractor, courts consider 4 factors. Always good to note if you're hiring people, by the way. 1, selection and engagement. 2, payment of compensation. 3, power of dismissal. And 4, power to control the work of the individual. The 4th factor, the power to control, is determinative. Right. Can you control what that person's doing? Mr. Depp has not been able to identify any Virginia Supreme Court authority squarely considering the specific issues of 1, an attorney retained in connection with litigation as an independent contractor, right, because why wouldn't it come up? And 2, whether the principle limiting liability for conduct of an independent contractor applies in the principal agent conduct context, specifically with respect to an attorney-client relationship. This is the thing. The courts haven't considered it. The courts haven't considered it. There is no superior court or Supreme Court ruling where they've even considered this because it just doesn't come up. So this seems to be a matter of first impression for the appeals court, which is going to make all of the appellate nerds go like this. Yay! It's novel. It's new. What do we do? We have all types of fun things that we get to look at fresh for the first time. So for the kids, no case law in Virginia is what they said. And Virginia is what matters. So appellate nerds, rejoice. Notably, the Virginia Supreme Court has cited with apparent approval, the restatements approach, which limits liability of a principal for the actions of a non-servant agent. And that would be the restatement of torts. Because it hasn't come up. However, although other jurisdictions are not uniform, the majority rule and the rule that should be adopted by the court is that an attorney retained by a client for litigation, though undoubtedly an agent of the client in the litigation, nevertheless stands in the capacity of a non-servant agent, e.g. an independent contractor, and therefore the client is generally not vicariously liable for the lawyer's misconduct, absent exceptions to the general rule that are not present here. Although the authorities are not unanimous, most other jurisdictions that have considered the issue have concluded that attorneys retained in litigation act as independent contractors, and those jurisdictions have accordingly imposed limits on clients' liability for tortious acts of their attorneys. That just makes sense. That just makes sense. It just makes sense. It just makes sense. It doesn't make sense to hold somebody who hires an independent contractor liable for what the independent contractor does outside of like limited and specific circumstances. All right. And this is going through case law from other jurisdictions, a large sampling of case law. They're like, we've got pages to spare because they brought narrow issues. So they got stacks and stacks of pages to spare so they can give you all the case law from everywhere else that they think helps, including independent counsel retained to conduct litigation in the courts, act in the capacity of independent contractors, Plant versus Trust of Columbus, a Georgia case. Under traditional master-servant law, the attorney was an independent contractor. We think the unique attorney-client relationship should not be analyzed merely with reference to ordinary agency law, and on and on. So let's get out of they've cited all of the case law. There are sound reasons why multiple jurisdictions have concluded that vicarious liability should have a limited application in the context of the attorney-client relationship. Lawyers, as legal professionals, typically are not subject to their client's control.
Don't tell Elaine. Don't tell Elaine that you're not subject to your client's control, because I feel like that was maybe missing in, the entire trial. Maybe.
Typically not subject to their client's control with respect to the manner in which they provide their services. If clients cannot control the details of their attorney's work, it makes little sense that clients should nonetheless be held accountable for their attorney's tortious actions. Attorneys generally are not subject to their client's actual control or direction. Indeed, most clients have an attorney because they are unfamiliar with the law and want it. Yeah. Let's describe why you hire an attorney. You are unfamiliar with the law and want the attorney to guide them through the intricacies of that field. As professionals, attorneys are deemed responsible for their own acts. Unless you're in California, apparently, but that's a whole nother side note. Go check out this morning's stream and my reel on Instagram regarding attorneys being held accountable for their own actions, Tom Girardi. But most clients have legal recourse against the attorney and his law firm for their actions. Yes, generally. Generally. Although a lawyer is subject to the client's direction with respect to the goal of representation, it is the lawyer who has wide discretion as to the means by which those goals are achieved. Because they have to follow, legal ethics and rules of court and the law. In every American jurisdiction, including Virginia, a lawyer is required to exercise independent professional judgment and is subject to independent professional and ethical obligations. A lawyer shall abide by a client's decisions concerning the objections of representation and shall consult the clients as to the means by which they are pursued. Hey, would you like to just sue them or do you want to send a cease and desist? Hey, these are the causes of action that make sense. Are there any that don't make sense to you? Let's have a conversation. Hey, this is what the settlement they're proposing is. Do you want to do that or not? This is the plus and minus. Let's pro and con this shit together. Those types of things are discussed. But your client can't say things to you like, don't turn over that discovery. And, you have to still follow the rules. In representing a client, a lawyer shall exercise independent professional judgments and render candid advice. Sometimes that candid advice is, this is not going to go well for you. Further, a lawyer is prohibited from advancing frivolous arguments on behalf of a client, Virginia Rule of Professional Conduct 3.1, and a lawyer has a duty of candor to the court and is permitted to refuse to present evidence on behalf of a client that the lawyer reasonably believes is false. Interesting that these are the rules. There's shade. There's shade in this. There is so much shade in this. They are making this example and making a statement at the same time. They could have given an example of any rules of professional conduct. They didn't have to give examples of rules of professional conduct to the appellate court, simply saying attorneys are held to not just what their client wants, but also to these rules of professional conduct. The fact that they are bringing up not advancing evidence that the lawyer reasonably believes is false, I am reading as shade. You let me know. You let me know if you are reading it as shade. I am reading it as shade. Maybe I'm reading too much into it. Always possible. There are lots of rules of professional conduct. A lawyer is, in sum, required to exercise professional expertise beyond that of a typical client. A lawyer shall provide competent representation to a client. Competent goes a little bit beyond, I'm trying my best. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. Is this whole paragraph shade? It might well be. It might well be. You must be candid and competent. There are accordingly substantial limitations on a client's ability to control the activities of the lawyer. The typical client who generally lacks legal expertise, that's why you get a lawyer, cannot monitor the conduct of a lawyer for wrongful activity. As a client's agent, the lawyer's conduct may be binding on the client with respect to positions taken in litigation or in a business transaction. The things that are done in court. But to hold a client liable for an attorney's intentional tort goes a step too far and is fundamentally inconsistent with logic beyond independent contractor principles of limited liability. All the happy squirrels. Is it shade or an eclipse? Yes, Ben Shu might just be a snarky guy. Because where does this slippery slope end, right? In court is one thing. Hey, your attorney said that this was settling. We've got a settlement agreement. We're not changing positions now. We're not changing course now. Things like that. But out of court statements, not in court with litigation, is that a step too far? And that's what they're arguing it is. Here, the evidence established that Mr. Waldman was retained by Depp as his attorney. He acted in the capacity in several litigation matters, including initial stages of the litigation against Heard. Other facts that underline Waldman's role as an independent contractor, only, are that he is the managing partner of his own law firm, has clients other than Mr. Depp, and offers legal services to other clients, not just hired by Depp. Heard presented no evidence that Depp was personally involved in directing or making the Waldman statements. In fact, the uncontroverted evidence was that Depp never even saw the Waldman statements prior to seeing Heard's counterclaim in August 2020. Accordingly, the premise of Heard's counterclaim is that Mr. Depp is liable for Waldman's statements for no other reason than Waldman was his attorney. No one appears to dispute that Waldman did not act in any capacity for Mr. Depp other than his attorney. As Mr. Depp's attorney, Waldman should have been considered an independent contractor whose tortious activity, if any, cannot be imputed to Mr. Depp without some other proof of direct direction or control. Okay. Starkey said deniable shade, which is also fair. What do you mean shade? We didn't intend any shade. We were just pointing out the rules of professional liability by way of example. The uncontroverted evidence, it says, established that Mr. Waldman was only an independent contractor for Mr. Depp as a matter of law. Therefore, Ms. Heard cannot hold Mr. Depp liable for any of the Waldman statements, and the trial court erred in denying Depp's motion to strike the counterclaim. Heading B. Ms. Heard presented no evidence of Mr. Waldman's actual malice. Even if the court were to conclude that Depp could be held liable, I love these arguments. You just walk through the argument. A, you can't hold him liable. B, even if you do hold him liable, this is why it fails. C, even if 1 and 2 above, this is why it fails. You just walk through the arguments. Strongest one first. Strongest one first is you don't even go here. You can't be held liable for this. Even if the court were to conclude Mr. Depp could be held liable for Waldman's alleged tortious conduct, the trial court nevertheless erred in denying the motion for summary judgment and motion to strike because Heard failed to present evidence to establish one of the required elements of defamation. Specifically, Heard failed to present evidence that Waldman acted with actual malice when he made the April 27th statement. As noted above, Heard chose to pursue a theory of vicarious liability against Depp at trial. She did not ask the jury to find Mr. Depp was directly involved in making the statements, nor did she present any evidence that would permit that conclusion. Vicarious liability is, quote, liability for the tort of another person. Tort means thing you can be sued for, action you can be sued for, not criminal. A vicarious claim, therefore, cannot proceed against an employer or principal absent a showing that the agent or employer committed a tort. And then it goes through a number of other cases making that same point from other jurisdictions and Virginia. Because a principal cannot be vicariously liable for his agent's tort unless the agent committed all elements of the tort in the first place, Mr. Depp cannot be vicariously liable for Waldman's alleged tort unless Heard carried her burden of proving that Waldman committed every element of defamation. Element number 1, publication. Number 2, an actionable statement. Number 3, the requisite intent. With respect to the requisite intent, a plaintiff who is a public figure such as Ms. Heard, footnote 5, must prove that a false and defamatory statement was made with actual malice, i.e. subjective knowledge that it was false or with a reckless disregard to whether it was false or not. Footnote 5. Oh, no, it will not. It will not. Footnote 5. No one has disputed that Ms. Heard is a public figure who must meet the actual malice standard, as she is a well-known actress whose activities are widely reported in the media. Yup. Including in the very Daily Mail articles that form the basis of her counterclaim. Indeed, Miss Heard's proposed jury instructions regarding Miss Heard's counterclaim, which were ultimately given without objection or appeal by Miss Heard, set forth the actual malice standard. It's been conceded. The point's been conceded. It goes on to quote case law saying, in order to establish actual malice, a plaintiff must demonstrate by clear and convincing evidence that the defendant realized that his statement was false or that he subjectively entertained serious doubt as to the truth of the statement. They showed nothing about it. You guys can probably think for yourself what things went to actual malice with regard to Amber Heard. She was there when all of this happened. They showed the jury the side-by-side pictures that she said were different times, but they were not different times in the metadata, things like that. So there was a lot of different evidence where a jury, because you can't get into someone's mind and be like, what were you thinking? But a lot of things where the jury can reasonably infer what was being thought. So with that, I think there's room in this case, really a lot of room to argue they proved nothing to show the state of mind of Adam Waldman if he knew these statements were false, if he was reckless to their falsity or not. And I think it's a strong argument, truly a strong argument. So it keeps going to say, importantly, actual malice is a subjective standard that examines the actual beliefs of the person publishing the defamatory statement at issue. Consequently, actual malice is not measured by whether a reasonably prudent man would have published or would have investigated before publishing. Rather, quote, there must be significant evidence to permit the conclusion that a defendant in fact entertained serious doubts as to the truth of the publication. Like, were you there? In fact, you drank a lot of wine that day. Were you there? Like, were you there? And all the evidence is that he was not there at all. So now how do you prove malice? We have reached interesting legal questions that will be reviewed de novo. Thus, for instance, a mere failure to reasonably investigate the truth of one's words is not enough to establish actual malice because it does not establish subjective knowledge of falsity. Indeed, quote, in the context of the actual malice inquiry, a duty to investigate the accuracy of one's statements does not arise until the publisher of those statements has a high degree of subjective awareness of their probable falsity. Where was that in the record? Where was the probable falsity? Where was it? Thus, to succeed on her defamation claim against Mr. Depp, Ms. Heard was required to establish by clear and convincing evidence that when Mr. Waldman made the statements, he either knew that they were false or he subjectively had a high degree of awareness that they were probably false. Clear and convincing evidence is, quote, that measure of degree or proof which will produce in the mind of the trier of fact a firm belief or conviction as to the allegations sought to be established. It then says, on review, appellate courts, quote, must exercise independent judgment and determine whether the record establishes actual malice with convincing clarity. That's going to be very interesting. They might not get to this question. The appellate court might choose to answer the larger question here about the independent contractor and not even get to the question. And appellate courts will do this. If I answer question one, I will not address the other questions because why address them? So they really might just address the independent contractor issue and not get to this. But if they get to this, I will be very interested to see what they say about the proof of actual malice. The independent contractor question, I think, is a legally cleaner question for them to address. This gets much more fact specific, and appellate courts will tend to defer in highly fact specific circumstances to the finder of fact, the jury, not themselves. It goes on to argue that Heard presented no evidence, much less clear and convincing evidence, that Waldman made the April 27th statement with actual malice. I truly don't disagree with that. Indeed, with respect to the April 27th Waldman statement, Ms. Heard presented no evidence regarding whether Waldman believed his statement was true or false. Footnote 6. Oh, we need a drink of water for this one. Ms. Heard's counsel did ask whether Mr. Waldman relied on information from Mr. Depp in making the statement. Mr. Depp's counsel asserted the attorney-client privilege and instructed Mr. Waldman not to answer, since the question directly invaded attorney-client communications. Ms. Heard did not move to compel a further response, nor could she plausibly have prevailed had she done so. Nor can any inference be drawn from any objections or instructions not to answer. The jury was specifically instructed not to draw any inference from the assertion of the objection or instruction not to answer. Another instruction that is not the subject of Ms. Heard's appeal, and of course, no adverse inferences arise from the mere assertion of attorney-client privilege. And then it cites case law to that fact, and the jury was told that. All evidence adducing at trial let me start that again. All evidence adduced at trial pertaining to Mr. Waldman's state of mind when he made the Waldman statements shows that Mr. Waldman believed that these statements were true. Waldman testified at length, for example, about why he believed Ms. Heard's allegations of abuse were false, citing testimony from multiple witnesses that contradicted Heard's account of events, including discrepancy in Heard's own story. In fact, Waldman testified that he filed a claim with the LAPD against Heard for perjury due to her claims that Mr. Depp abused her, and that he presented them with information, binders of information, if I recall, that he believed established her perjury. Since Heard presented no evidence that would permit the jury to find by clear and convincing evidence that Waldman subjectively knew that his statements were actually or probably false, the trial court erred in denying the motion to strike the evidence, and the judgment in Ms. Heard's favor on the April 27th statements must be reversed. In context, it says the Waldman statements are not actionable. I love how they've ordered the arguments strongest and easiest for the court to decide on to not as clear-cut and not as strong. The strongest argument is the independent contractor argument. It's a good argument. Next is you didn't prove any malice, a little muddier because it gets into factual determinations made by the jury. And the third one is there's all this context, but some of the context is stuff that the court's going to be really, really hesitant to let in as an exhibit, truly. All right, let's keep going. In context, the Waldman statements are not actionable. Even if the court believed that Mr. Depp could be liable for the statements, Ms. Heard's counterclaim for defamation is still fundamentally defective because, read in context, the statements are not an actionable statement of fact. The trial court thus erred in not granting the motion for summary judgment. I bet they'll spend the least amount of time on this argument. Pure expressions of opinions not amounting to fighting words cannot form the basis for an action for defamation. The First Amendment to the Federal Constitution, Article 1, Section 12 and Article 1, Section 12 of the Constitution of Virginia protect the right of the people to teach, preach, write, or speak any such opinion, however ill-founded, without inhibition by actions for libel and slander. Conversely, however, quote, there is no constitutional value in false statements of fact. By the way, can we just, the Virginia Constitution, teach, preach, write, or speak. I love the way they kind of like summarized it down in their own state constitution. Thus, in an action for defamation, it says a court must resolve as a threshold matter whether an alleged defamatory statement is one of fact or opinion. A statement of fact is one with a provably false connotation or which can reasonably be interpreted as stating actual facts about a person. However, even a provably false statement is not actionable if it is plain that the speaker is expressing a subjective view, an interpretation, a theory, conjecture, or surmise, rather than claiming to be in possession of objectively verifiable facts. So saying things like, I have a source is leading towards objectively verifiable facts. Saying things like, well, it's my opinion that blah, blah, blah is different. Though we're talking about defamation. You can still run into issues with false light. This is not legal advice. But this is breaking down those circumstances of defamation. Importantly, in assessing whether alleged defamatory words are fact or opinion, the court must examine them in context, with the aim being to interpret them, quote, as other people would understand them. So the argument being, hey, no one's reading these statements redacted. If anyone's reading this article in the Daily Mail, which we can presume, we can speculate, we can conject that lots of people read it, um, then they would have read it in context of the whole article, not just in a little snippet of a sentence. The way that the Amber Heard written article in the paper and digital article were presented into evidence. Though I will say this is not an easy call for Judge A, because there are definitely things in that article that would be really, really, really hard to put in front of a jury. So backing up, because I sidebarred in the middle of that, it says to examine them in context, quote, as other people would understand them and according to the sense in which they appear to have been used in the totality of the circumstances. Thus, in considering whether a statement's audience would understand it as a statement of fact or opinion, courts consider such factors as the form in which the alleged defamatory statements were uttered. Like, was it a cartoon in a newspaper or was it an op-ed? Whether an audience familiar with the form would expect to hear an opinion. Is this published in The Onion or is it published in the Washington Post? If a statement is made in a form in which a reader would be likely to recognize that the critiques represented in represent the highly subjective opinions of the author, like an op-ed, maybe, or like a Reddit thread. Are you treating something said on Reddit or Twitter differently than you're treating something in a media publication? That might have changed, though, in recent years. All of this might have changed, where people are like, I don't care if it's said by, a journalist. I don't care if it's said by CNN or NBC or ABC or any of the three letters. I don't know if I believe it at all. And maybe this has changed, but what they're talking about is where it's written matters. Daily Mail versus a Reddit forum and whatever. It also goes on to say courts consider the degree to which the statement's audience is familiar with the underlying facts and therefore able to assess the defamatory statements for themselves. And then it cites case law on that. Courts also consider the identity of the speaker and whether the speaker's biases are known and disclosed to the audience. So Depp's lawyer versus not Depp's lawyer. Further, courts can consider whether the speaker claims to have personal knowledge or is merely drawing inferences about events he does not claim to have witnessed. And now they're going to give us the statement in context again. The statement presented to the jury, and then it's the exact same one we've read earlier up. When read in isolation, this could arguably be interpreted as a factual statement sufficient to state a claim for defamation. When viewed in context, however, it is non-actionable opinion. Importantly, the April 27th Waldman statement is presented as a statement by a lawyer in the context of litigation and necessarily represents only one side of a heated debate. Further, it was made to a reporter who presented quotes from both sides of the debate and was necessarily aware that the facts were hotly disputed. Indeed, the April 27th article quotes Ms. Heard's attorney referring to Waldman's statements as fantasies. That's a very interesting argument. If it says within the same article, those statements are fantasies, they're conspiracy speculations, then is the reader reading the article, not the jury, but the reader reading the article going to say, oh, Heard's attorneys say this and Depp's attorneys say that. Ooh, I wonder who I agree with. I wonder who's right. There are two sides of this and they do not agree. I think it's more likely that a reader would treat it that way because you're reading both sides of it. Mr. Waldman never claims personal knowledge of what happened on May 21st, 2016 at Depp and Heard's shared penthouse. No one disputes this. Rather, it's clear from the April 27th article that Waldman was speaking as a legal advocate, offering his own interpretation of disputed evidence. The April 27th statement is thus most reasonably understood as an attorney's interpretation of the conflicting allegations and evidence in a he said, she said dispute, and as such cannot be defamatory. And then they go through case law regarding that. Let's see. In context, it's clear that each of Waldman's statements, including the April 27th Waldman statement, reflect a subjective view and interpretation, a theory, conjecture, or surmise. Footnote 7. This analysis holds true of all the Waldman statements, as each were made to reporters who acknowledged and described the clash of two fundamentally different versions of events from Mr. Depp and Ms. Heard. Each acknowledged Mr. Waldman's bias and status as an attorney for Depp. He's not biased. He's an advocate. I mean, I guess bias makes sense in the context of the case law, but he's an advocate for Depp. He's an advocate for Depp. That's his job, to advocate for Depp. Waldman's own interpretation of the weight, reliability, and credibility of conflicting evidence about which he did not claim to and did not have direct firsthand personal knowledge. It's a fair argument. I think the arguments above, that he doesn't even go here anyway and Depp can't be held liable, is easier for the appellate court to consider. And if it's not been considered, it's going to make their little appellate nerd hearts go, ooh, new. We get to look at something new, versus saying, the jury got this one wrong. The court should have yeeted this earlier. It's much cleaner for an appellate court to not say the court got this wrong, but to say the law on this area wasn't clear. And now we're going to make it perfectly clear in our jurisdiction. Much easier for them to address, I think. So the Waldman statement reflects a subjective view and interpretation, theory, conjecture, or surmise, so as to be non-actionable opinion. It goes on to say Mr. Waldman indisputably had no personal knowledge of what happened at the ECB, yet no one said he was there. The evidence presented at trial shows that Mr. Waldman subjectively believed, based on the evidence he had collected and reviewed, that Ms. Heard's claims of abuse against Depp were false, right? Because he was Depp's lawyer at the time. And so in the April 27th statement, Waldman was merely drawing inferences and speculating based on the evidence available to him what must have happened on May 21st, 2016. This reasoned, good faith interpretation of the evidence cannot be defamatory. The trial court accordingly erred in denying the summary judgment and motion to strike. Summary judgment being yeet it before trial, motion to strike being the evidence is closed, yeet it now. The trial court erred in denying the proposed jury instruction. Standard of review. Jury instructions are reviewed under abuse of discretion standards. Way harder to find. In reviewing a trial court's, quote, decision to refuse jury instructions, the evidence is viewed in the light most favorable to the proponent of the instruction. Whether the content of the instruction is an accurate statement of the relevant legal principles is a question of law that, like all questions of law, is subject to review de novo. If a proffered instruction finds any support in credible evidence, its refusal is reversible error. So saying, look, this instruction should have been given, it can be reversible error. These, again, are ordered, I think, in arguments that are strongest to arguments that are more, I'm not saying weak arguments, but arguments that are more difficult for the court to find. Finding an abuse of discretion is something, again, that courts are hesitant to do. Finding that the law is not clear in an area is just saying, let's clear it up. Discussion. Evidence was presented from which the jury could have found that Mr. Waldman was an independent contractor. At trial, Depp proposed jury instructions numbers 22. Quote, this is the jury instruction. An independent contractor is a person who engaged to produce a specific result, but who is not subject to the control of the employer/principal as to the way he brings about that result. If you find that Mr. Waldman was acting on Mr. Depp's behalf, but was not subject to Mr. Depp's control in that manner, method, or means by which Mr. Waldman worked, you must find that Mr. Waldman was an independent contractor. I think that accurately states the law to what we've seen. And then in the parentheses, it says an outside lawyer retained by a client in connection with litigation is an independent contractor. And then it cites where it is. And, well, that would direct the jury. That was jury instruction 23, that directing the jury that an outside lawyer retained by a client in connection with litigation is an independent contractor. That's saying as a matter of law, you have to find that which means they can't find defamation at all, because as a matter of law, you're instructing the jury. So that one's more interesting than the first one because I think that's a little harder. And 24, a person who hires an independent contractor is not liable for the independent contractor's actions. If you find that Mr. Waldman was an independent contractor of Mr. Depp instead of an employee, you may not find Mr. Depp liable for Waldman's conduct. The court denied these instructions. I want to go back and watch the arguments over these instructions because we saw them all. I think the court could have given 24 and 22 and not given 23, and then it wouldn't be directing them as a matter of law. It would be letting them decide. But it kind of is a matter of law whether somebody's an independent contractor or not. Imagine going to the state of California and being like, it's like my opinion that they're an independent contractor. That's why I'm not paying them a W-2. That's why I'm not paying employment and payroll taxes. It's my opinion that they're an independent contractor. The state would be, fuck you. And we're going to also charge you interest on everything that you haven't paid us and then fine you. Party on. It's not how that works. It really is a matter of law. It goes on to say, Mr. Depp incorporates by reference and will not repeat at length the arguments set forth above. Well, thank you so much. You also probably have a page limit. Regarding Waldman's status as an independent contractor, in sum, since the evidence supports finding Waldman was an independent contractor, his allegedly tortious conduct cannot be imputed to Depp. I think it's fair. I think that's fair. The evidence at trial established that Waldman represented Depp solely as an attorney in not vicarious litigation manners, various litigation manners, but in no other capacity. As such, the court should adopt the majority position of other jurisdictions. Even if the court declines to adopt a per se rule, evidence was presented from which the jury could reasonably have found Mr. Waldman was an independent contractor, not subject to his client control. And that's saying, hey, you've got to give the jury the room to decide by giving this instruction. So even if the court doesn't want to rule like they did up above, even if you don't want to make a new rule, even if you don't want to get here and find that then the jury instructions should have been given and the jury should have decided. But then the result is different. I'm just going to interrupt myself. We're going to sidebar for a minute. So if the court goes up above and is like, we're going to review this law and find that this vicarious liability theory fails, that's as a matter of law. And there's not really much to do other than remand it back to the trial court and reverse the jury finding and judgment and just yeet it and say, you win on nothing, you take nothing, and you get nothing. If they find it on the jury instructions, the result would likely be refer it back, remand it back to the trial court and say, do it again on these claims and give this instruction. And then it wouldn't be over. It would be up for a retrial. And oh, fucking hell. Would they retry it? Maybe not. Maybe not. But it wouldn't be as definitive. If they find it as a matter of law, it can be definitive and done with no retrial. That's why these are ordered this way. Because this result, what would happen in this result is not as favorable to Johnny Depp as what would happen if they addressed it on the earlier grounds that we covered. The trial court erred in excluding the full text of the articles. Standard of review: the trial court's decision to admit or exclude evidence is reviewed under an abuse of discretion standard. Again, the de novo standard's better for Depp. The abuse of discretion standard is a little bit harder. Discussion. The unredacted articles provided necessary context, and we talked about that up above. This will probably be brief. We're getting towards the end of this brief. The brief at the end of the brief. At trial, Depp sought to introduce unredacted copies of the 3 Daily Mail articles containing each of the statements. The trial court excluded them as hearsay, admitting only copies that had everything but the Waldman statements redacted. The court's apparent reasoning was that the Daily Mail articles were written by reporters, not Waldman, so the context that matters is the context in which Mr. Waldman made the statements to the reporters, not the context in which the statement appears in the articles. Huh. That's interesting. You know, I enjoy Judge A. I do, but that reasoning is odd to me. That reasoning, let's reason through this for a second together. We're going to just pause here. The apparent reasoning is that because Waldman said it to reporters, The context of the statement for it to be defamatory is the context in which Waldman said it to the reporter and not the context in which the reader received it and not the context that they appear in the articles. I agree with them that I disagree, because it's defamatory not when Waldman, she's not suing because Waldman said it to a reporter. She's suing because it was in the Daily Mail. So the way it's read by the public in the Daily Mail is the context that matters for determining if it's defamatory. This could have been, that's fair. Sin Book Dragon said, was that Judge A or the previous judge? I believe that this was Judge A because this was determined closer to trial, not the previous judge. And so that's why I think this was a Judge A ruling, but that reasoning doesn't follow for me. So we'll have to see. They reserved all the context, so the court will go back and look at the appeals court will go back and look at the reasoning of the trial court on this. But I don't think that's the proper context. It has to be the context that the public's consuming it in, because that's how it's being sued for. As set forth in section 4A4 supra, in assessing whether a statement is actionable for defamation, context is paramount. While the context in which Mr. Waldman made the original statement to the reporters is relevant, the contents of the article are also relevant. For instance, the full articles in which the statement appears are also relevant to how the reporters and ultimately the readers understood the Waldman statements as presenting one side's interpretation of evidence gathered in a hotly contested litigation. Further, the April 27th article includes additional quotes from Waldman that put the statement in context, identifying the evidence he's interpreting. And I can see why the court's hesitant about this, because what Waldman is saying in the article is this is the evidence, but that's evidence that's also contested in this trial. It says, but even this didn't have the desired effect because two domestic abuse trained LAPD police would later provide a pair of sworn depositions saying they saw no evidence of a crime. However, that evidence did come in trial. It did. The full articles in which the Waldman statements appeared are relevant to assess what, if any, damages Heard purportedly sustained from them. In assessing whether Heard suffered any damages from the Waldman statements, the jury should have been able to consider that the statements were buried at the bottom of a salacious tabloid article and surrounded by substantial additional commentary about Mr. Depp and Miss Heard, little of which was flattering to either of them. I mean, fair. The trial court erred in excluding the articles in their full context. Conclusion: the court should reverse the judgment on Miss Heard's counterclaims as to the Waldman statement, but should otherwise affirm the judgment in Johnny Depp's favor. Signed by Benjamin Chu. Does that mean he wrote the whole thing? No. Does that mean he was involved? Absolutely. He's the one who signed it. Hey, Ari, good to see you in the chat, lady. And that is that. 44 pages of appellate record. Y'all, we did it. Cheers. I'm going to get to questions and I'm going to give additional thoughts. Question, or thoughts first, then questions. I think there are some really, really good arguments here. Not arguments that I'm going, good luck with that, but actual, real, meaty questions of law. Like, how do you hold someone responsible for what their independent contractor said when it seems contrary to the law of the land? That's a real fair question. How did they make this balance of what the jury can hear and what they can't hear to give context? Because if the context needed is that both attorneys are making statements in this article, then is the reader really taking that as fact, or is the reader taking that as two different sides of the same piece of evidence? And does that matter whether it's defamatory? Yes. So I think it's a strong brief. I think they make good arguments. I'll be really interested to see what the reply brief said. And as I checked this morning, I'm going to check again because I haven't checked later in the day because I told you earlier what my day was like. She's unfortunately way too booked and busy lately, which makes it hard. So let's go. Let's just pull it back up and see if there's any note that other appellate brief has been filed. Let's look for a note. Let's go. So I'm just pulling up the database now. We're going to punch in the case number, hopefully better than I did this morning and faster. Nope. Why does it do it that way? Why won't you let me put in all of the numbers? Oh, there it is. All right, great. Good enough for government work. No, there's no note. No note. Car's gone. God damn it. I spend too much time on TikTok. All right. This is where it would say when the opening brief was received. It doesn't. As we know from Rob, who practices in this jurisdiction, they have 10 days after. She actually filed the extension. I don't see it noted on here. So she could have. That's absolutely true. She could have filed an extension. I just don't see it on this record. And if they gave her an extension, fine. They're going to have to ask for a page extension too, I imagine. But I just haven't seen the filing. So she might have. I just haven't seen it. So, but again, these dockets are not easy. I'll go look for it. I just haven't seen it on this because these dockets are not easy. The CAV received, the record received, the designation, the appellee designation, and that's all I can see on this end. So I can go back and look for it. I don't doubt that happened. So with that, Chelsea said November should be slow. Emily's regretting it. I should never say it. And you know what? My podcast editor, Dan, said, don't say that. Don't say that ever. And I did. So I have questions. You have questions. We have questions. We're like an hour and 36 minutes in. Let's take some questions. We're going to fack around and find out. That's not the right bumper, Emily. Wrong bumper, babe. Let's get it together. We've got a trial in January. We have to get used to streaming all day again. We have to pull it back together. Because the Murdoch case is in January. All right. So go ahead and put your questions in the chat. I'm going to try to get to as many. Just put either a question mark or a Q or question at the beginning. I know there's a character limit, so writing out question can be hard, but this. Catherine said, wouldn't the employee contractor issue be quickly settled by determining whether a W-2 or a W-9 issued? I don't think it's contested that he's actually an independent contractor. I think what they're pointing out is, as a matter of law, an independent contractor can't be an independent contractor. An independent contractor's client can't be held vicariously liable for an intentional tort. That is the train of logic. So he has to be an independent contractor. And I don't think they even need to get to W-9, W-2, because when you're paying the company, there wouldn't even be a W-9 and there wouldn't be a W-2. You just pay the company. So he would just pay his lawyer. And so I don't think they even need to prove that. So let's see. From Kim over on the Facebooks. Hello to the Facebooks. Don't forget, I didn't even talk about the YouTube-y thing. Don't forget to do the YouTube-y things and the Facebook-y things. Go ahead and follow the page over on Facebook. I know there's a lot of you that like having the smaller chat over on Facebook, because over on Facebook, there's about 460 of you. And over on YouTube, there's about 13,000 of you. So I understand why some of you are like, no, Facebook is my jam. I get it. So don't forget to do the thingy things. Question, how can she state she is homeless? So that is me being cheeky with the language. Technically, she's stating that she is stateless. I'm going to break down the law on that in a podcast episode. I just didn't have the bandwidth to do it on a live stream. So I'm going to break it down on a podcast episode talking about the law behind her arguments that because she is a woman without a state, there is no diversity jurisdiction, because that gets into like lawful law real quick. like law. It's not a easy to explain. It is a layered argument about what in fact diversity jurisdiction is, what domicile is, when those things are defeated, and I want to read the case law cited, and I want to pull up the statutes. We are going to literally just go to the book and break down her argument because I'm personally very interested. I think y'all are interested. But also, I don't think Amber Heard is just domiciled in another country. Like, I don't know. I've never tried to live in another country. We have a large international audience here. We have people that are expats from the US, people who are expats in other countries, living in other countries. You can't just show up and be like, I live here now. This is other than, I just want to know what her visa status is. Where are you living? Are you a resident? Are you visiting? What kind of visa are you on where? Have you established residency, actual residency in another country? I don't think she did. And I don't think she's established actual residency in another country before the lawsuit was filed in July. It's ridiculous, but I'm interested. Elizabeth said, I've lived in 4 countries and I laugh in expat. She's like, wait, what is our laughs in expat voice? Hold on. We're going to pick one. I don't know if the robot's the right vibe. Maybe this. Laughs in expat. That sounded really loud. Maybe that was the right one. So that. She can't establish residency on a waiver visa, and I have no idea what her visa is. They put in no evidence. Like there's no evidence. Yolanda said, look at Shakira's issues. Yes, also with Spain with Shakira's issues. And we will have to pull up the Shakira case again. We went through it quickly, but we'll have to pull up the Shakira case because Shakira's like, I wasn't a resident here. You can't tax me. And these where you are and where you're domiciled and where you live, it's just Ems is like, I'm laughing, an EU citizen. Well, it's very much different for y'all in the EU. Lynn said if she's living in Spain under a visa that gives her status there, what happens? They have to prove it. But even then, I don't think she was domiciled or a resident in Spain before the lawsuit was filed. I don't think this is the topic for the podcast. I want to read the case law, but I still don't think it's going to work. I think it's too little too late. I think we are throwing spaghetti at the wall. So, Yolanda said it's a 6-month thing both ways. I imagine this is not a fast thing. And we know that she was in the US like April, May, June. This lawsuit was filed in July, so I don't think she established domicile elsewhere adequately in a month. Truly, visiting and traveling abroad is not the same. Laughing in blue British passport. You guys are hilarious. So we will go there. Cheeky Chops, I'm reading this wrong. I don't think I'm reading Dom's the way that you're meaning it, and I can't wrap my brain because it's late and we're in a cheeky mood. So I don't know. Have a safe word, ask for consent. That's where I'm at with that answer. It's probably not what you intended. Let's see. I'm only just joining now since my break at work has started a bit behind, so I'm restarting the stream for me. Hopefully I'll hear you read this out. Keep up the great work. Unlawful. Thank you. I did. And cheers. I hope you have a great break at work. Cheryl C said she still owns a company in California too. And signed the policy. Like there's a lot of things. There's a lot of things that go into this. And that's next week's podcast. I haven't had a chance to go all the way through it. Gonna be doctor soon too. So she watched Daryl Brooks and thought it was a good idea. I don't know if she was like, Daryl Brooks, hold my kombucha. I don't know. Maybe. Beats Kill Bean said, accountant here, law firm lawyers are issued 1099 NECs by clients for services. There you go. Non-employee compensation. I mean, it just makes sense that they are. But again, I worked for the government as an attorney, so not something I worried about. And my accountants deal with it now. When I pay my attorneys, the accountants deal with it. 13,000 here and only 3.6K likes. Mash that like button, people. Thank you. Also loved the mods. Huge love to the mods for writing again. They were like, yes, yes. Kelly said that Andrea said, after second period, in the case law, they cite a person who had lived out of state for 6 years. Yeah, that's a significant difference, which is why, again, I want to read the case. I just haven't had a chance yet. Didn't Amber Heard sell her house after the court case decision? Amber Heard sold her house according to media reports, which are based on Zillow, and Zillow can be wrong. So caveat. It says that she sold her house after the lawsuit was filed in California by New York Marine. But yes, it was also after the Johnny Depp Amber Heard lawsuit. There she ring goes. I'm sorry. It happens. We're after dark. And that's what happens. We're after dark. We're after dark. All right, let's keep going to questions and getting to some of the super chats. Question, do both sides get a chance to respond to the briefs of the other? Yes, they do. Both sides get a chance. So there's an opening brief, a opposition or responsive brief, and then a reply to the opposition. And then they can set it for oral argument. Can we all just send up our prayers to the universe, to God, to Awa, to the force, to you pick who we're sending it to the appellate gods that be, that this goes to oral argument. Why? Because we can access oral argument in Virginia online. And wouldn't that be great? I want to hear the oral argument on this case. It doesn't mean it'll get to oral argument, but I really want it to. Finley said, question, what trial is in January? I'm newer and obsessed with your channel. Planning ahead. Finley, the Murdaugh murder case is set to go forth in January. I don't know if it will. I don't know if it won't. Things do get pushed over. It does happen that cases go later, but the Murdaugh case is a wild case out of South Carolina. I have a couple podcast episodes about it. Mandy Matney has an entire podcast dedicated to just that case. Apparently there's a new HBO Plus something I haven't seen yet about it, but this is a lawyer that has a whole bunch of legal fuckery and stealing from clients going on, and a murder for hire gone wrong. And the trial in January, he is accused of killing his wife and son. It is absolutely, every time I look at the Murdaugh case, I'm like, I'm sorry, what? I'm sorry, what? I'm sorry, what? I'm sorry, what? Like, what? Wait, what? Every single time I look at something from that case, I'm like, no. What? No. That case is staggering to me. Absolutely staggering to me. So, the Murdaugh case. Though cases do get put over. Sophie S said, UK gang team, no sleep. We try to keep our stuff to 11 a.m. I've got a whole bunch of things tomorrow and a football game because Friday. So today I'm hopping on a plane on Monday. We should just put up a poll. I'll put up something in the community tab about what fuckery is going to pop off on Monday. Will it be live streamed? I believed it will be live streamed. Mandy is live tweeting her watching it right now. It's a lot of pro Murdaugh propaganda. Mandy Matney's done just incredible work. Just absolutely incredible work. And has shown tremendous integrity and grit. I just love it. Love the peanut butter whiskey recommendation. Cheers. I love a peanut butter whiskey. And I'm out of salty watermelon and it's fall, so it's time to switch to like salted caramel. But right now I'm in a peanut butter mood. Got my objection here. Say thermos today. So happy. Donna, I'm glad you love it. That's over at lawnerdshop.com. It's so good. It's so good. We have more stuff coming for you guys this month. If Emily can ever sit down and get to work. Like, I was supposed to work more today and now I'm here. My poor team is like, Emily, did you get this done? I'm like, so I decided to do an extra stream Sorry that I didn't get to any of my emails. They basically just have to parent me all the time. It's like, can we manage her to make her get her work done? Emily, you have to sit down and get work done. I'm like, we're just gonna stream instead. The desire to stream is real. Alex F said, I just had to join in. Love your stuff so much. Much love from North Alabama. Hello, Bama. Stina G said that font seems appropriate for Johnny Depp, doesn't it? It's a good font. Waiting for Johnny Depp's next tattoo in the font from the appeals court in Virginia. Would you die? I would die. That might be a little too meta, but can you imagine? Can you imagine an like an I won tattoo? We'll see what happens in this court of appeals, but I can see it. I mean, it's a very interesting font. I need to know exactly which font it is. I'll have to go look it up. Unapologetically, Cece said, yay, you're back. Love a double dose day of Emily. LOL. Huge fan. And Brain Twinsy, Santa Monica, and Coke Dream Zero. What is a Coke Dream Zero? Dream, not the Minecraft streamer, right? What is a Coke Dream Zero? I don't know. There are things I don't know. There are things I don't know. Y'all are in here saying roll tide. Look, I see ya. I see you, but isn't Tennessee ranked number 1 or something in the football-y things? Question, that font is Black Chancery. Oh, okay. Or just Megapint in that font. Well, that would be brilliant. Pumpkin spice whiskey. Does it exist? If it exists, I'm there. Like say more in basic to me. Pumpkin spice whiskey. Yes. Yes. Mara said, I recently was diagnosed with inattentive ADHD and feel at home when my quirks are present on an EDB stream. Yeah. I can't mask anymore. Once I started working for myself, and we talked about this in the members only live a bit when I was just talking about me, once I started breaking down kind of the shame and embarrassment, I just am me and I'm okay with being me. And there are times where we can like suppress the urge to be like, what the fuck? But also I get to just be myself on stream. I talked about it on the Hot Messy Topics podcast with Up and Adam and his fiance Down with Jason, which was great. It's just, I get to just be me. I don't have the brain capacity or the stamina to be anyone other than myself. I am just this. I can be appropriate in contexts where I need to be appropriate and professional, but when I'm streaming with y'all, I get to just be myself, and that is such a blessing. So for all of you that are like the random interruptions of song and what have you, yeah, it's literally just how my brain connects things together, and sometimes that works well, and sometimes it annoys the hell out of me, but we're always just going to embrace it. So football things, yes, football things. Sherry Day said, yes, we are, go Vols. See, there it is. So we just embrace it. Somebody said Tennessee is number 2. I think that's slander. I'm being facetious. Did they change the ratings? I don't know. When I saw it the other day, they were number 1. And the only reason I was talking about it is because Hogue was talking about the ranking of Michigan. I was like, oh yeah, isn't Tennessee like not number 5? Like, aren't they number 1 or something in sports ball? He's like, what? Also, didn't go to Tennessee, moved to Tennessee, chosen home. So is it ridiculous of me to use that as a flex? Yes, absolutely. I'm aware. Sitting here, cat on lap, appeal, cinnamon, mead in hand. That sounds delightful. It's 1 a.m. waiting for Emily to start. Love from the Netherlands. That sounds like a wonderful night, Sharon. Mary said Vino in Chicago. Miss EDB has a fan and I'm here for it. Love it. Have you had barbecue whiskey? No. We had to finish singing Robin Hood. Oodalolly, oodalolly. Golly, what a day. Did you fall for the fox in Robin Hood? Why do they make cartoon foxes hot is the question. If you don't want everybody to simp for the fox in Robin Hood, don't make him hot, obviously. But Emily also reads a whole lot of fantasy books. So, there's that. Marla said, that isn't a legal team. It's an army. We do have a legal army. AH's appeal has a different number. It does. AH's appeal and Johnny Depp's appeal have separate numbers because they are separate. Hers and obviously. Crystal said, I'm so excited for a night stream. Hello from Australia. Hello, Australia. It's been a while since we've gotten to do a night stream. Victoria, thank you for the compliments. Thank you for creating such a lovely community. And all the work you do with this channel snaps to the editors and mods because they're amazing. AH, throwing everything at the wall. Something has to stick eventually. It doesn't, though. Grammy said, Emily, I found you at the beginning of Depp v. Heard and love you and the fact that you love old movies. Sorry, I missed their... See, they don't feel like old movies to me. They feel like the movies of my childhood. Oh, I just screwed up my camera. Sorry, y'all. My camera is like, we don't autofocus anymore. Stop snapping at us. Sorry, I missed the reaction of your family after watching Princess Bride, my favorite. My kiddo, my 14-year-old, loved it. But today also, my 14-year-old is funny. Emily, those frames, brand and where? Probably LensCrafters. I think these are Dolce & Gabbana. I don't know. I go in and I look for the cat eye ones because it's a shape that I really like. And I need a glass that like just has a good shape. So I think they're Dolce & Gabbana. Elaine is not part of the appellate team and is probably happy to not be part of the appellate team. But Elaine is also pending deposition in the insurance cases that we're going to be talking about on next week's Emily show. It's a lot. Alex said, teething 10-month-old and sick 5-year-old. I am so sorry. I am so sorry. I'm happy to catch the stream. Love the content. You're welcome. I'm so sorry. Question, what happens if they win an appeal? Amanda, we broke it down really well, I think, with the two different options. There's a few things the appellate court can do. The appellate court can say, as a matter of law, this cannot stand. Like, as a matter of law, this is legally impossible. It's legally impossible to find an independent contractor that the person that hired them can be vicariously liable for their actions. Legally impossible. It's not lawful law. It has a legal infirmity. So then it's done. You can overturn the conviction, not criminal. You can overturn the finding of liability and overturn the judgment, and it's done. Or they can say the judge erred in that jury instruction, do over. Or they can say, yes, there was an error made, but it's harmless error. We're not going to do anything about it. Yes, there's error. We acknowledge it. It's harmless. Everything stays as is. So there's a few options. Chad is petitioning for a Law Nerd Spotify playlist, please. I think that needs to happen. I've been wanting to reach out to Spotify about other things, and I saw the way that they did a playlist for the fitness marshal, and I was like, I bet we could do something like that. I bet we could. Beverly, me, nothing on TV. Oh my God, Emily, better than TV. I mean, you could actually put me on your TV if you'd like. You can do that. Most smart TVs have YouTubes, and then you can just chat in the thing I hate about mobile chat though, is it doesn't let you like tag people and respond. Josephine says, if it pleases EDB, the Law Nerds want a Law Nerd Spotify playlist. It does. Motion granted. I'll figure it out. We'll figure it out. I want to do an official one with Spotify. We'll make that happen. You're back. Backstreet's back. All right. I went to a Backstreet Boys concert once. Wait, I think Chris, who's on my team, was at that Backstreet Boys concert with me. Here's the best thing about a Backstreet Boys concert. One, tons of parking because everyone's parents dropped them off. Two, no line for alcohol. None at all. Because everyone there was under the age that you could drink. It was fun. It was a good time. Thanks for being so informative, funny, and respectful. You're welcome. But is this lawful law? I think that we've got some lawful law from Team Depp. I think this was a really good brief. Thanks so much for your candor and explanations. Of course. Jay Fernandez said, I'm ready. It has all the shade, and I'm hearing shout outs to ECB. That was definitely some shade. How would you render the interjection Elaine in a brief? Well, I think we got a few in there. So these were from hours ago. I think we got a few. Shade and tea are my favorite pastime. Oh my God. My kid and I, while we were stuck in Travis and I were stuck in traffic today, we were listening to, I don't know what song he put on by Scissor Sisters, but we were listening to it. And then I was like, no, they have Take Your Mama Out. And he's like, what? And I was like, okay, play it. The next song that came out was Let's Have a Kiki. And he's like, what in the world is this? So I was trying to explain a Kiki to my 14-year-old. It was fun. We've had a Kiki here tonight, a legal Kiki. Birdie over on Facebook said Christopher Melcher, who's an attorney who does commentary on Twitter and then on various channels around the interwebs, strongly feels that Team Depp has thrown Adam Waldman under the bus by not asking him during his deposition what job he was hired to do at the time he made those statements in the Daily Mail. I don't know. I'll go look at what Christopher Melcher said. Also, I don't know if Team Depp's strategy I have found to be very good. I don't know if it was asked and then they lost an objection and it was edited out or not, but I will have to go back and look at that testimony. And I'd be interested to see what Christopher Melcher says. The thing I love about lawyers is you put 5 lawyers in a room and they're all going to be like, well, what about this? And what about this? And what about that? It's why you have lawyers working together to talk things through, because everyone's going to see things differently. And that's literally the point of having coworkers. It's so helpful to talk things through. It's why lawyers at Stream, we enjoy having conversations, or I can speak for myself. I enjoy having conversations with other lawyers because we all see things from different perspectives. Question, would trial appeal judges read appeals for their case? I don't even know if they would have time. I don't know. They don't have to. I don't know if they'd have time. I don't know if they'd want to. It's like, don't read the comments. This was a very respectful appeal, but it's like, don't read the comments. Don't read the comments. This would be the equivalent. Cheryl asked, what would be the reason for Amber Heard lawyers needing an extension for the appeal filing? Isn't that what they should be working on? Could that go against them? I don't think it'll go against them. They might need more time. Amber Heard's attorneys also might have difficulty communicating with her if she doesn't live in the country. They also brought on appellate counsel later. So to be fair to Amber Heard's attorneys, Johnny Depp's team, his appellate team, is in the same firm as his trial team. They are all doing this work together. Amber Heard brought on a new legal team. Yes, a few of the lawyers stayed, but brought on a new legal team who needs to get up to speed. It's not as easy for them. So it's totally fair, I think. And really with appeals, it's not like they're on a huge rush. I really don't think it's the end of the world. And I don't think it'll be held against them. It's pretty standard. Long shot, but do you think the jury awarded on this one knowing it'd be easiest to appeal? No, I honestly think that the jury looked at it and went, well, I don't think Adam Waldman's version of events is right. I think that's how they got there, and that's why they found on that one and not the other two. Truly, I think that's how they got there when I look at these verdicts together. But no, temporary placating AH, but affording JD the last laugh. Why waste everyone's time and money? I don't think that they thought it through that deeply. I really don't. I think it was like, that doesn't seem true. Or that's contrary to the evidence that we saw, but that doesn't mean there's actual malice. Talia, question, anyone know where EDB's sweater is from? I need warm, soft things with thumb holes. I love a thumb hole. This is probably from Target or Truly or Costco. I don't know. It depends on who it's it's probably from one of those places. Most of my thumb hole things tend to be from Target. I love a thumb hole. I also have short arms, like a T-Rex. So thumb hole things can be too long, and it can look intentional. And I ridiculously drink iced coffee even in the winter, so it keeps my hands warm as I drink my iced coffee. Lori, this made me laugh and nerd. Amber Heard is stateless, like not a gas, liquid, or solid. Exactly. Exactly like that. It's exactly like that. Athletica has lovely thumbhole stuff. We love thumbhole stuff. We love thumbhole stuff. T-Rex arm gang. It's fair. It's absolutely fair. So let's see. We are going to have to get to the rest of these real quick. Question. This is a great question, Barnabas. I thought Johnny won. How is there an appeal? At the beginning of stream, we address it. He lost on one count. So Alex said, not a question, just wanted to throw you some love. Thank you for the support. Question, if she is stateless, how can she file in federal court? The two The two are not the same. So this does not rely on diversity jurisdiction. This is not a new case. So the two things are not synonymous. She has the right to fight. God, she can fight for her right to party. No, she can still appeal the verdict. They had jurisdiction over her. That was found when this went to trial. So different grounds. Different grounds. Question: does the appellate court have to have received briefs from both parties before ruling on one or both? No, they're separate appeals. So if the Johnny Depp appeal moves along faster, they can rule on the Johnny Depp appeal before ruling on the Amber Heard appeal. They might not, because they want them to be consistent. But the legal grounds that we've seen in the designations on Amber Heard don't really relate to this. So it's completely different grounds. And so because of when this is due, then the reply brief will be due. So they can do them separately. But if they want to go to oral argument and they have all the attorneys, they might just have them argue both on the same day and then catch them up together and decide them in a similar time frame. It just depends on what they want to do. And that's going to be a decision for the judges. Judy E said, this was really interesting. Thanks. Well, thank you. I try to be interesting and occasionally quippy. Rebecca says, as an insurance defense attorney, it makes my law nerd heart full to see issues and law I'm familiar with coming to life in pop culture. Rebecca, right? The insurance attorneys are like, wait, she's arguing she's stateless. Interesting. Tiffany said, are the actual appellate hearings that can be attended publicly, or is this all on paper? If they go to oral argument, they will be streamed. The audio will be streamed. They might do a video feed too in Virginia, so you can watch them. Thank you for keeping me awake during overtime. Well, you're welcome. The law nerds are here for you. Question: did your dog step on a bee? No, but really, I think you're pretty great. Thank you. Love hearing your commentary. I appreciate it, Jay Huck. Revelstoke in Canada has a pumpkin flavored whiskey. Oh, all of you. Yes. Old Smoky has a pumpkin spice cream moonshine. What? And a pumpkin pie moonshine. I need to get to the liquor store. That's what I need to do. Also, several options for other pumpkin spice booze. Rattlesnake Rosie's pumpkin pie whiskey has the best bottle from what I'm seeing. Thank you, law nerds, for keeping me entertained and liquored. Ari, shout out to anyone dealing with the Adderall shortage. Check out Dr. Daniel Amen's book for tips on how to cope without meds. Love you, Emily. Thanks, Ari. I mean, we have a large ADD crew here. Heading to our first BOA regional this weekend. Tips, congratulations, Nicole. Bring things for all weather. Stadium seats are helpful. And what else? Have fun. Make sure you get some food and just enjoy it. It's a lot of fun. It really is. Throwing spaghetti at the wall can result in a lot of pages. It may not stick, but it does get read. Yeah, and we will absolutely read it. And it will probably end up with code red at some point. Hello from Zionsville, Indiana, with peanut butter cup coffee in hand and a dog on my lap. I know it's not pop culture, but I'm wrapped in the Delphi case. Yay for an arrest. I have not decided yet when or if we will cover it. People are like, what are your thoughts? I'm like, people were arrested? So, for the kids, Emily, are you coming to celebrate Abby's win? I will be in California with my friend who is running for judge for election day and night. Yes, I will. So fingers crossed. I don't want to jinx things by speaking them out loud, but yes, I am coming, to spend time with my friend for the election. Elections are stressful, y'all. Y'all know that as voters, y'all know that, but elections are stressful when you're the candidate, even in a judicial race, which is not a political office, still very, very stressful. Let's see. Answer: FYI, on the VCA site, you can click on the top right where it says last inquiry, just so you know. Oh, yes, I can. Thank you. Question: I like your earrings. Thank you. More of a statement, but I'm here for it. They are Kendra Scott. I like the shape. Beats Kill Bean says, Amber Heard logic: pledge equals donate, citizenship equals residency. Or not. Let's see. Can we get a poll for it? Maybe the next time. Abby B said, she's an Abby. She must win. I hope so. Abby B, not only is she an Abby, she's an Abby B. So if you guys are in Los Angeles County, plug for my friend, Abby Barron for judge. You might have seen her on local billboards and other things. So that. Wait, Jessica, what? Starbucks has the pretty blue Stanley mugs like yours, Emily. Wait, they do? Again? I need to go to Starbucks. New mugs got dropped today and my day was super busy. Tomorrow, I might be late to my first meeting. I might need to go to Starbucks. I might need to go to Starbucks. I might need to go to Starbucks tomorrow morning. No, I can go early like an adult and be on time. I'm from Delphi and it hurts to hear people talk about it given how small our community is. I hope they move it out of our county. Anelia, thank you. At this point, there was an arrest made and there's not much more I can offer. It's like, I try to do things that I can help with. There's not much I can help with in that an arrest has been made and we'll go from there. What hair dye do you use? I need to ask my hairdresser. It is twinkle twinkle time. Yes, it is. It is. Thank you. The mod's getting my attention. Hello from Manchester, Tennessee. Love your content, positive vibes. Thank you so much from Manchester. I've been to Manchester a few times. I actually know where that is. Kendra Scott gives 50% off one item during your birthday month. And they generally do stuff for Black Friday and all of that. So it's time. It's time. All right. With that, y'all, we should absolutely start to wrap. So it is definitely twinkle twinkle time. Thank you all for your support. Thank you for being here. Thanks for being law nerds. We have covered the Johnny Depp appeal opening brief. There will be a reply brief or an opposition brief, and then there will be a reply to that. I don't know what they call them in Virginia. Normally an opposition brief, could be a responsive brief. Either way, we will cover when Amber Heard's team responds to Depp. We will cover it. When Depp responds back, we will cover it. When Amber Heard files her opening brief, we will cover it. And so on and so on. We're in this forever and ever and ever. Bridget said it's a dark blue, not the same blue. So cute. I'm here for it either way. I'm on a mission now. I'm on a mission tomorrow. Cups away. My husband's gonna be like, "What are you doing?" What he doesn't know is that I just ordered two new Stanley water cups because I don't want to take. When I go do stuff with the family, I don't want to take my precious because I don't want to drop the pretties and break them and not be able to get them again or have to go on like eBay and pay $1 million for them. So I don't like taking them out and about. I like keeping them on my desk and at the house or in the background of the things. So, and this one especially, it glows so bright at night. I just love it. So I got 2 new Stanley mugs that are coming so I can take them to kid events and not worry about them as much. You guys also on Facebook, if you get political, you will just earn yourself a block for being a dick. So just a word to those on the Facebooks. Thank you, the Facebook crew. I know sometimes you have to put up with a few trolls, especially when the streams get big. Thank you always for your patience with that. It's just ridiculous. All right. With that, y'all, have a good night. Thank you for being here. Thank you for being a law nerd. If you didn't watch this week's episode of the podcast, it's up on the channel now and on your favorite podcasting app. It's called The Emily Show. Don't forget to leave it a review. If you're listening on the audio, it helps people find it. It actually really does help. So with that, do the YouTubey things, the likey, subscribey things, and I will see you in the next one. I'm flying on Monday. Fingers crossed that nothing pops off. Today was wild. Just fingers crossed. Okay, cheers. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.